International justice can feel kind of abstract, right? Something that happens in these big, fancy halls far away from our daily lives. But how does it actually begin? How does a simple disagreement between two countries over a little piece of land end up at the world's court? Well, today we're going to follow the real paper trail of a 1957 case to see exactly how it's done step by step. So it all kicks off with this one single document, a letter. It lands at the International Court of Justice, the ICJ, from the Netherlands Minister of Foreign Affairs. And it's doing one thing, officially submitting a dispute with their neighbor, Belgium, over two tiny plots of land on their border. And just like that, the clock starts ticking. Okay, so that first letter really gets the ball rolling. Let's break down what happens in this first official step, filing the case. Now, here's a super important term you've got to know. A special agreement, or as it's known in French, a compromis. This is crucial. It means this isn't some angry lawsuit where one country is dragging the other to court. Not at all. It means both the Netherlands and Belgium have agreed to be here. They've worked together to define the exact question they need answered and are jointly asking the court for a final binding decision. Right away, both countries appoint their official point person, who's called an agent. Think of them as the main channel of communication between their government and the court. And look who they chose. Both nations picked the top legal advisors from their foreign affairs ministries. That tells you right there just how seriously they're taking this whole thing. Now, this case might just be between two neighbors, but the whole world is about to be put on notice. See, the ICJ is the main court of the United Nations. So its registrar zips a telegram over to the UN Secretary General in New York. And from there, the news goes out to all the other member states. Hey, everyone, there's a new case on the docket. With the case officially filed, the president of the court steps in to set the calendar. International justice isn't a free-for-all. From the very beginning, it's all about process and, you guessed it, deadlines. And they don't waste any time. On December 12th, 1957, just a couple of weeks after that first letter arrived, the president of the court issues an order. It lays out the first two big deadlines for what's called the written pleadings. Basically, Belgium has to submit its main argument first, and then the Netherlands gets a few months to prepare and file its response. So that first big document is called the memorial. You can think of it as the opening shot. It's where Belgium is going to lay all its cards on the table. The history, the facts, the legal arguments, the whole shebang. It's their complete case, all down on paper. So remember how the UN was notified? Well, that's when this case stops being a private conversation. The world starts to tune in, and other countries begin paying very close attention. And sure enough, a few months later, a letter shows up from literally the other side of the world. It's from the ambassador of Chile. He's writing to the court to formally ask for copies of all the legal documents that have been filed in this little Belgian-Dutch border case. Which kind of makes you wonder, right? Why on earth would Chile, thousands of miles away, be so interested in a small disagreement over a couple plots of land in Europe? And the answer gets right to the heart of why the World Court is such a big deal. Here's the key takeaway. Rulings from this court, even in minor cases, can create legal precedents. They can have ripple effects all over the globe, changing how international law is understood and used by everyone. A decision about an old European treaty could one day affect a totally different case in South America. Every nation really does have a stake in the outcome. This whole exchange also shows you just how transparent the process is. The court asks both Belgium and the Netherlands, hey, are you guys cool with sharing your files with Chile? And pretty quickly, they both write back saying, yep, we have no objection. The process is designed to be open for the whole world to see. Okay, so the world is officially watching. Now, the real legal arguments get started. This is the written phase, and it's a very structured back-and-forth exchange. It's basically a four-step dance. Step 1, the applicant, Belgium, files its memorial. Step 2, the respondent, the Netherlands, files a counter-memorial to rebut that argument. Step 3, the applicant gets another turn, filing a reply to the rebuttal. And finally, Step 4, the respondent gets the last written word with a document called a rejoinder. It's all designed so that each side gets a totally fair shot to make its case. And boom, right on schedule, February 25th, 1958, 2 days ahead of the deadline, Belgium's ambassador delivers their memorial to the court. We're talking hundreds of pages laying out their claim. So step 1 is done. The ball is now officially in the Netherlands court. But in law, just like in life, things don't always go exactly to plan. Just as the Netherlands is getting its response ready, there's a bit of an unexpected snag. On May 16th, only 2 weeks before their big deadline, the Dutch agent writes to the court. He explains that, and I'm paraphrasing the French here, some unforeseen circumstances have made it impossible for them to file on time. So what happened? Well, their main lawyer for the case had just been given a new job and had to step down, just like that. So they formally ask for an extension. So what happens now? Does it turn into a big fight? Nope. First, the court asks Belgium what it thinks. Belgium writes back and says it sees no inconvenience with the request. See, even though they're on opposite sides, there's this professional courtesy. So, with both sides in agreement, the court president makes it official and moves the deadline to the end of June. All right, with that little delay sorted out, the written arguments pick back up. And over the next year, that case file gets thicker and thicker as both sides build their arguments, all in preparation for the next big phase, the actual hearing. And here's how the rest of it played out. The Netherlands meets that new deadline at the end of June with its counter-memorial. Then, that fall, Belgium submits its reply. And finally, in the spring of 1959, the Netherlands files its rejoinder, the fourth and final piece of the puzzle. And this is the moment. The Dutch agent submits their final document, which is also called a duplique in French. With this filing on March 31st, 1959, the paper trail is officially complete. Both sides have said everything they're going to say, at least on paper. After more than a year of back and forth, the court officially declares the case en état, which is a fancy way of saying it is ready to proceed. This is a huge milestone. The judges now have everything in front of them, every argument, every map, every historical document. The paper war is over. The stage is set for the oral hearings. So, this massive foundation has been built, letter by letter, document by document. But a mountain of paper isn't a verdict, right? The question now is, how do you turn all these centuries of treaties, maps, and laws into an actual final judgment? Well, that is what happens next when these words come to life inside the courtroom.